Let's top the morning off with business and immigration law updates. This is a presentation of the Khurana Law Firm located in Rockville, Maryland. Here, the Chief Attorney at Law is Mr. Ramesh Khurana. On this set, the moderator is Attorney Kenneth Haber, who questions Attorney Khurana on removing conditions on permanent residence based on marriage. Let's have a look.
Welcome. I'm Kenneth Haber, and this is the Capitol Forum. I'm a former Assistant U.S. Attorney and a former Senior Attorney in the Office of Inspector General. But with those credentials, they pale in comparison to this man right here, Ramesh Khurana, who is an immigration attorney that has served people across the world and across this country, helping them to get a start in this country as citizens and residents of this country. Welcome, Ramesh.
Thank you. You are so kind on me. I cannot excel, When I compare myself with you, oh my God, I know that you are the best defense attorney in your field. So, of course, I know immigration laws, but I do not know criminal laws. And you do your job best.
Well, I appreciate that, but if I had an immigration case, I would certainly want you on it. And matter of fact, you were on it when I brought my wife over.
Yeah, I appreciate that.
Can we discuss this time the removal of conditions on permanent residency on the green card?
Sure, Ken, I'll be happy to do that. First of all, for the benefit of audience, let me describe what is the conditional green card. Whenever somebody gets married and applies for the immigration benefit in the form of a green card, and marriage is not more than 2 years old as of the date of filing an application, so that person is given a conditional green card. That means that card is valid only for a period of 2 years. After 2 years, it lapses. So why they are putting this condition on the green card? Because of so many immigration frauds which are taking place, or rather I would say so many marriage frauds which are taking place. So they would like to revisit the whole issue after 2 years and see whatever attestations were made by the applicant and the petitioner at the time of applying for the green card, whether those are true or not. And after they have reviewed the application, then they would extend the green card. If USCIS is satisfied, then they will review it on a permanent basis. Of course, green card is valid for 10 years then.
What are the procedures that apply to obtaining the removal of condition on the green card?
Ken, the most important thing which people have to remember is that when the card is likely to expire on the second anniversary, date is given on the card. Please note it on your calendar very carefully. Don't let this date go away. In fact, you are required to file within 90 days before the expiry date. That doesn't mean that you cannot apply within 80 days or 60 days, but that is the expectation. Reason is very simple, because there are some processing delays. When you apply for removal of the condition on your green card, now your green card is going to lapse after 2 years. And if you don't apply on time, you do not have any extension of your green card, and you are working on a job and your employer would tell you, you do not have the work authorization, your green card lapsed on such and such date, show me the proof, and you will be sitting out of job. And there is no way that you can have the process expedited by paying additional fee, like we call it a premium processing basis, etc. There is nothing like this in the matter of removal of condition. So file 90 days in advance so that condition is removed, and then of course whatever is the processing time before the final decision is made, you have to wait for it. Now you talked about the procedure. Now you have to file the immigration form I-751. Now this will be signed both by the husband and wife. So they will say, yes, we continue to be married, and they will provide certain documentation in proof of the marriage, and this would be like commingling of assets by them, having joint bank accounts, having filed joint tax returns over the last 2 years, having joint credit cards, having joint health insurance, life insurance, etc. So, you provide all these documentation along with form I-751, file it in a timely manner. Hopefully, if it is a bona fide marriage, the waiver, the condition should be removed, and you will get a letter from the USCIS. They will say, on a preliminary review, we are processing your application. It may take some time, but they issue a kind of letter on a security paper, and they say that your green card is extended by 1 year. That's why in answer to your first question, I said, if you do not file this application, your green card may expire and you may be sitting out of job. So, when you get this letter whereby your green card status is extended by 1 year, then you can show it to your employer, or if you are a self-employed, of course, there are no such issues. So, based on that, you continue to work, and it takes somewhere between, I would say, 4 months to 9 months before the condition is approved and you get your new card.
You're a mind reader. That was my next question was going to be. What about if you're no longer married? What's your eligibility to apply for removal of the condition? You were in a bona fide marriage, but the guy turned out to be an abuser, and you decided adios. You're not going to stick around for it.
Then you make my life much easier by explaining the question to me. So, you are asking me to explain a situation whereby one spouse has been abused by the other spouse and the marriage has been terminated. That means they have been divorced, and I hope the marriage was not annulled, because you use the term that it was a bona fide marriage. Now, under the circumstances, marriage is terminated despite the fact in the first place this was a bona fide marriage, absolutely no problem. So, in that kind of situation, only the spouse, now that spouse will be filing a request for waiver of joint application, and she would give enough evidence to prove that it was a bona fide marriage. Now, how do you prove the bona fide marriage? You have got to be very creative. Let us say when marriage took place, you filed a joint tax return. Give a copy of the joint tax return, which would show husband and wife, and you opened some joint bank accounts. Give copies of your bank account statements. Maybe you are on the same credit card, provide copies of the credit cards. Maybe you are on the same telephone family plan, so give a copy of the contract. So, maybe you are on the same lease. So, they recognize that this is a fact of life, that people do have irreconcilable differences, and they get separated, they get divorced. But in the first place, if this is a bona fide marriage, so I do not foresee any problems in removal of condition of 2 years.
What if it was an annulment? Let's say that it was a bona fide marriage, but then due to religious reasons, a person wants an annulment based upon misrepresentations of the spouse. And within their church, they needed annulment in order to be able to get remarried. Does that pose a problem for people with the immigration officials?
So, the way I understand your question is like they are alleging, though one spouse thinks that it was a bona fide marriage, but your allegation is the other person got married with an intent to get the immigration benefit.
Not even that. What if it was not intent for the immigration benefit, but that there was something concealed from the other spouse? Say that there was abuse, the person had a pattern of abuse, and the person wanted to get annulment so that they can later on get married. Where in their church they couldn't get married again if there was not an annulment. Would that requirement for the church be in conflict with the immigration
Oh,
steps?
definitely. Whatever is the real intent, it's not that for one purpose there is a different line of action, and for immigration purposes it's a different line of action. So, normally, let me give you an example. Until recently, people were getting married in India, and there was no need to register that marriage. Like you have, we have the system here in the United States. First of all, you get the marriage license, and then you get married. So in India, people would go to temples, and they will go to churches. They would get married, and the priest would issue a marriage certificate, and there was no need to register that marriage with the registrar of marriages until such time Supreme Court came out with an opinion that marriage is not legally valid unless it is registered with the registrar of marriages. Now, after that Supreme Court judgment, unless you register your marriage in India, it's not a valid marriage. Otherwise, being an attorney, you know that once a marriage is solemnized and it is recognized by the jurisdiction, when we say jurisdiction, it may be a foreign country under the Hague Convention, and if it is valid as per the laws of the particular countries where the marriage was solemnized, it will be considered valid in the United States. So, it depends upon the validity of the marriage where marriage is taking place, and you cannot argue different grounds or different situations for different purposes. That is not less than fraud. That's a fraudulent misrepresentation.
How can a person get a waiver in terms of filing a joint petition to remove conditions on the green card?
Again, in answer to your first question, Ken, I said that Form I-751, which is filed with the USCIS to remove the condition on the green card, now that has to be signed both by the husband and the wife. Now, when we are talking about how a person can get the waiver, if husband and wife have been divorced or she has become a widow, there could be different circumstances. So, based upon the circumstances, she has to explain her situation to the USCIS, like there is a death of the spouse, no problem, attach the death certificate, explain it, like this is what has happened, there cannot be a joint petition, like they have been divorced, explain the situation, we have been divorced, enclose the marriage certificate again which was filed at the time of applying for the green card. Now, along with that you enclose your court's divorce decree. So, you are proving, and of course, court will come back and ask you, give us a copy of the complaint and the answer which were filed in the court. They would like to see what were the allegations in the divorce proceeding. Sometimes people say, she got married with me because she just wanted to obtain a green card, and the sole purpose was to obtain the green card. In that kind of situation, the court may not touch that topic, because court will say, you are here, you meet the requirements of the state law, like in Maryland you have to be separated for 1 year. So, you meet with that requirement and you have proven that there is no intent to continue to have this marriage and there are irreconcilable differences or some other reason. So, there is no reason that why the divorce should not be granted.
It gets rather complicated, doesn't it?
Yes, law we are dealing with is always complicated.
That's for
It's
sure.
always complicated.
Well, you certainly help simplify some of the issues, and for those issues that are not, you have some advice for people?
Yes, my advice is that immigration issues are very complex in nature, and always talk to your immigration lawyer before you get trapped because of certain mistakes, and be properly guided and you will be fine.
Thank you very much.
Thank you very much.